good afternoon, or I suppose good morning, depending on where you're joining us from. I'm David Singleton, and I am a professor of law and the Dean for Experiential and Clinical Programs at the University of the District of Columbia David A. Clark School of Law. I'm really excited to begin our fourth episode of our fifth season of Conversation with Clinicians series. For those of you who are unable to join us for our previous episodes this season, we spent those 3 episodes exploring collaborations between social work programs and law clinics. You can find these episodes along with the many illuminating conversations during previous seasons on our website. And you can find a link to those previous episodes in the chat. So a little bit about Conversations with Clinicians, if this is your first time joining. Conversations with Clinicians features UDC School of Law clinicians in discussion with leaders in the experiential education field. As early leaders in clinical legal education and at a school where our students all take between 10 to 14 mandatory clinic credits as a graduation requirement, we developed this series to create a space where clinicians across the country and perhaps even the world can engage in topics of interest while exploring some of the most pressing issues facing our community. So just a note about how we're going to proceed with this session. We'll start with cameras off until we reach the question and answer portion later in the program. And then please, at that point, turn on your videos. I'm especially thrilled today to have Professor Ngozi Ndulue, who directs our post-conviction criminal defense clinic. And by the way, just let me say this. I have known Ngozi since she was in law school. We were colleagues at the Ohio Justice and Policy Center, working to try and get people out of prison. She's going to be in conversation with Yale Law School's Miriam Gohara. And Miriam, who is a clinical professor of law and director of the Jerome N. Frank Legal Services Organization, she is also someone I've known for years and just deeply admire. What they're going to talk about today is exploring clinics addressing mass incarceration through post-conviction advocacy. So with that said, I'm going to turn it over to you, Professor Ndulue.
Thank you so much, David. And David, as always, is too humble when he says we were colleagues. He was my boss. He was a great boss for several years. And it is wonderful for me to be here today because it is also a moment to reflect. So with David, that introduction for David, and also Miriam, I have known since law school. And I didn't ask you, Miriam, just because I'm like testing my memory here, but I think it was my first year when I was doing a volunteer project with the Capital Assistance Project, maybe, that we were helping you with something. Do you remember?
I think so too. And I appreciate the space because I want to say David Singleton was in the first class of lawyers at the Neighborhood Defender Service of Harlem, which is where I started my career. And he had moved on by the time I started, but David was legendary at the Neighborhood Defender Service. And then I was really lucky to get to know him later when he was in Ohio at the Ohio Justice and Policy Center, whose work I really admire, because speaking of post-conviction litigation in places that really need it, that was a pioneering office. And the work that you and David did there really was a model and remains a model for me. And I've consulted David, I've consulted you on tough cases. And yes, I've known you since you were in law school. And I think you were maybe you were even one of the founders of the Capital Assistance Project. I know that was something that started around the time you were in law school.
Yeah, I think it was before me, maybe the year before, but yeah.
Yeah.
So, and lest we forget how influential those law school experiences can be, right? David was a mentor in residence and spoke at law school, and that's how we got to know each other. So this is a good space for us, especially at this time, I think, of the semester where some of us may be scrambling to end, to remind ourselves of what difference that can make in students' lives. Well, first of all, I just want to thank you, Miriam, for agreeing to have this conversation today. For me, this comes out of your generosity in having conversations before I started at UDC Law this year. So when I thought about how to craft a post-conviction criminal defense clinic, Miriam was one of the first people that I thought about as far as who could actually talk about, how their work has evolved, knowing that she has the background of having years of experience doing this work and being able to translate that into a law school environment. So I'm seeing this as, I love fireside chat. So let's pretend we have the fire. Fireside chat. We're continuing our conversation about what does it mean to what are the nuts and bolts of creating a post-conviction criminal defense clinic? What do we think about when we're thinking about its impact on our clients, our students, on us, on the world in general? So we're going to kind of go from kind of the nitty gritty, what these are. Let's even define, what we're talking about, and then how these are set up, and then talk big about impact and what we've seen. So just first to start laying the groundwork and really focusing our conversation. So post-conviction advocacy in the criminal defense context can be a lot of things. It can be, motions for new trials after a jury verdict. It could be a direct appeal. It can be parole advocacy. There's so much more that can be, if you wanted to think broadly about post-conviction. So for me, in the first year of my clinic, my students have worked on state habeas petitions, motions in federal habeas proceedings, and medical release motions. I'd like to hear from you, Miriam, like what's the scope of the post-conviction advocacy that you and your students have done?
Yeah, thank you so much for inviting me to have this conversation. I was so excited to hear that you were going to be doing full-time clinical teaching and that you were excited about starting a post-conviction clinic. So it was truly my pleasure to talk with you then and to talk with you now. The way my clinic is structured is that the students and I work on cases that fall into kind of two categories. One is pre-sentencing cases where somebody is facing the prospect of incarceration, and those are only federal. We only do those in partnership with the Federal Defender's Office here in Connecticut. Then there's a second category, which is people who are incarcerated and we're trying to get their sentences reduced. Those can be either state or federal. So we've been doing some federal reduction in sentencing motions under what's now called the First Step Act, again, in partnership with the Federal Defender's Office. And I'll put a pin in that because I had some trepidation about doing that work for reasons I'll explain in a minute. And then we also do state post-conviction cases for clients who are incarcerated in Connecticut. And mostly we concentrate that work in one particular prison called the Cheshire Correctional Institution because they have a specific rehabilitation unit where the Department of Correction hand selects men who are serving long sentences to mentor younger people who are in that unit to prepare them for release. And because of this, the importance of the fact that the DOC has hand selected these leaders, I believe that they especially deserve a meaningful second chance. And when we get to more specifics later, I can explain the different sentencing mechanisms that we use to get their cases back in front of some decision maker, whether that's a parole board or a court. To go back to why I had a little bit of trepidation about doing the federal reduction in sentencing cases, because this goes to clinic design, it was really important to me that the students have a meaningful contact with clients. And that's a large part of the reason why I did not import my previous capital habeas practice into the clinic here when I started it, because all of my clients in that practice were in other states. And I wanted to make sure the students could really take the lead on client relationships. in the federal reduction in sentencing cases, even though the convictions have arisen in Connecticut, often the clients are in other states because, as we all know, the Federal Bureau of Prisons might send somebody anywhere. That's even more salient today, unfortunately. So I was worried about that. I thought, I don't necessarily know how that's going to work, but my colleagues in the Federal Defender's Office convinced me it was worth a try because they were really finding that it was an important opportunity to give federally incarcerated people a chance at really, really, deep dive advocacy. And I can describe more about what the advocacy model of the clinic looks like later too. So I agreed. And man, it has been so rewarding. I mean, the students have developed such rich relationships with the clients. Sometimes the clients are within driving distance, so they can go at least once or twice a semester to go and meet with the clients. But even when they've been forced to develop these relationships over the phone, it has just been amazing to see what kind of relationships they can build. And I will later when you ask me what my favorite moments are with students, I'll explain how impactful that's been on prison staff as well. So I want to just flag that when it came to clinic design, that was a question I had, and I'm happy to answer questions during Q&A if people share that. But it's been a really good, I'm glad my colleagues encouraged me to dive in.
That's great. Oh yeah, I feel there's about 10 follow-ups that I have for here and for later too, just from that little piece. But let's actually talk a little bit about clinic design. So for me, I feel like I've experienced two very different, um, clinics because I've had 2 semesters. I have a semester-long clinic. I have a 10 credit hour um, evening clinic that I did in the fall, and that was their only class. That was the luxury. And then the 7 credit hour class with mostly day students, full-time students, and where they have other classes. So as I'm sure you know, Miriam, that every class is kind of brand new, right? Different students, different energy. And we'll talk later about like some of the challenges that come with like, how long you have with the students and how much time that they have to devote to their cases. And I've learned so much in, just kind of being able to compare the two clinic semesters. I wonder for you about, how you've designed your clinic and also the changes that you have made over time.
Yeah, thank you. So the clinic is founded on the premise that the deep dive capital mitigation sentencing work that lawyers are supposed to do for death penalty clients at trial and in post-conviction is something that people who are serving long prison sentences or facing long prison sentences also deserve. So one of the things that really disturbed me when I was in capital practice is that people would get sentenced to life without parole without sometimes any consideration at all of their backgrounds, their history, what we call social history in the work. And certainly once they were in prison, they might not have anyone reviewing their sentences. That really bothered me. And as much of a curse as a death sentence is, at a minimum, most people will get somebody taking a look at that sentence at some point. Again, I'm not trying to say that the quality of counsel or the quality of review is anywhere near what it should be in most places, but a lot of people go to prison for a lot of years with nobody taking a second look. So when I had the opportunity to start the clinic, this was my priority. It was, I'm going to take everything I've learned from death penalty practice, and that has been from lawyers, but also from social workers. I know your series has talked about social workers in clinics, from mitigation specialists, psychologists, medical doctors, the paralegals. I've learned so much from so many different people in the death penalty community. And I thought I'm going to apply that to have really energetic and smart law students working on people's cases who are in prison serving long terms or maybe gonna serve long terms if we don't help them. So that was the impetus for the clinic design. The way it's changed is interesting. So in addition to what I mentioned at the beginning, first I was only doing like federal pre-sentencing and state post-conviction because clients were accessible in both. Then, of course, there was a change I already mentioned. We added federal reduction in sentencing. But in the first semester that I started the clinic, I was actually still a visitor at Yale Law School, so I hadn't been offered a permanent position. So I wanted to make sure that the cases were like transferable back to the federal defender's office if things, for whatever reason I didn't join permanently. So in what I now think, I can't believe we did this. We had only 4 students in the clinic at that time, because again, it was a pilot. Each team of 2 students had 2 cases. One was a federal case and one was a state post-conviction case. That's small, but less in scope than what we're doing now. But still, now it's totally different. Now we have teams of 2 to 4 students working on one case, and we really do a long time workup before anything gets filed, or we have enough lead time. Even federal sentencing, there's a lot of time between plea and sentencing or conviction and sentencing in federal court. So that's how it's changed in one of the main ways. Another thing that has been interesting is that the federal cases, I think we've really had even more of an emphasis on when clients can be bonded out before they're sentenced. We do so much work with the Federal Defender's Office and their team to get clients into programs or into employment, or the support that they needed before they ever ended up on the wrong side of the law for whatever reason. We do that so that when we're in court with the sentencing judge, we can say, look how well this person can do. Look how they can stay connected to their families. Look how well they do with a job. Look how well they do now that they've been afforded for the first time in their lives meaningful substance use treatment. And you don't need prison. In fact, prison will set them back from all that. So that's one of the ways it's changed. It's that we really put a lot of emphasis on the team helping to assemble the ideal set for the client. And it's not cookie cutter, and it's not some probation oriented, like you must do these programs. Not at all. It's our collaboration with the client to identify what the client needs to afford them an opportunity to shine before they're sentenced. And that has made a really big difference.
And that also seems like a really tie into like social work and the difference that could make, right? Like that idea of creating the resources and creating the team is something that I could see, very well, like the insights from social workers can be really helpful there.
Absolutely. And the Federal Defender's Office has social workers that work in the mitigation area. So that's huge for us. But really the students are working with those people hand in glove to, help the clients with that. So that's been really rewarding. And then for the clients who are incarcerated, the ones who are in the federal system don't often have access to a lot of programming. So a lot of times what we're finding is it's employment that they've plugged into, and it's their own self-generated groups, right? Their own self-generated support groups, reading groups, education, religious activities, whatever it is. In the state cases, as I mentioned, we're working with a specialized unit where our clients are building all that as well, but under the auspices of the DOC. And I should mention the Vera Institute of Justice also co-founded that unit. So it's a nice space. Yeah.
And did you say how long the students are in the clinic for?
Oh, yeah. So this is a luxury that I have to say Yale law students have. They get to start clinics in their first year if they want to. And so they can start second semester first year, and they don't have to necessarily move out of the clinic. So I know at a lot of law schools, because there's so much need and capacity for clinic space that students have to move through. So that is one thing that I think makes this clinic possible to have a certain approach, because the same student team will stay on. I've had students stay on for 5 semesters, and that's different than a scenario where I only have the students for 1 semester. Now, some students decide to leave. There's no like requirement they stay. Some students decide to leave, and then I'll just add new team members the next semester.
So it is like 1 to 5. You have kind of a pretty broad range here.
Yeah.
Okay.
But I've also had third years that join their second semester, third year, and they're on it for 1 semester, and they get the experience, and they help as much as they can, and they move on. So.
And I think we'll talk about that a little bit later when we think about like the length of post-conviction cases. So I want to kind of discuss how you handle that. And it's interesting with this kind of flexibility where you might have a little bit more continuity than others might. One of the things that's already come up is cases and how we get them and how we select them. And so I know for me, so you talked about the difference between like visiting and finding cases that you knew, you had the flexibility. So for me, for the first year when I was very focused on making sure that I was partnering with other people to work on. So I was working on pro bono cases. of attorneys that I just knew, right? Which was great for the ability to say, like, if, when the semester ended or when whatever project we were working on was over, to be able to kind of send that back to them, but also was different as far as like what choice, because it was not necessarily like, here I have 20 different cases and I have a specific criteria. There were definitely criteria that were going to be better, for me. Like timing was a big one. Is there a work product that we're going to be able to um, present, create by the end of the semester? Is this something that, there's enough work for a pair of students? Because I also had teams to do. So that was kind of my case selection mode for this year. I'm hoping next year to actually get some specific, especially because we are a DC public law school, DC specific cases where we are actually going to be able to spend a year between the two student groups to be able to do some sentence reduction cases for folks who are aging into a certain category. They've spent 15 years, they committed their crime when they were young adults. And so we're hoping to get at least one of those. I'm interested in your two cases per student piece, because I love to do, students on one of those, and on another kind of like consulting case where they're just doing a lot of kind of legal research and writing. We'll see. The dreams. But Miriam, talk to me about how you're getting, because you talked a lot about partnership and with the federal defenders. And can you talk also about like how you're getting cases, this partnership, and why that might be important? Because I think that's another thing to really think about with these types of clinics with such complex cases as well.
I didn't know anything about practice in Connecticut because all my work had been in death penalty cases, state or federal, before I started this. So, I mean, since, I was working at Neighborhood Defender Service early in my career in New York, that was not where I was, at the time I started the clinic. So I knew I needed to partner with lawyers that were in the community and knew what the community needed, and also what lawyers could benefit from in terms of additional support. And I was fortunate to have good relationships with the Federal Defender's Office, and I trusted the lawyers in leadership there. And so they trusted me, and we decided right away that we could bring in some law student energy and talent to help shore up mitigation in their cases. And they immediately bought into the model of the students being the leaders, the students being the ones who have the primary relationships with our clients, with their family members, with the students are the ones doing the investigation. We don't hire investigators. They're the ones investigating all the social history, collecting records, working with experts under our supervision, of course, but we're not the leaders, except in rare meetings. They prepare the clients for their probation meetings, pre-sentencing, for anyone who does federal sentencing work. Some people don't even have counsel in those meetings, which I can't imagine because they're so important and impactful on the judges. So the students lead all that. So that's why I decided to partner with the federal defenders. Now in the state system, I see Allie Harrington's on our call, and I'm excited to see her. She's at Buffalo. She was one of the leaders in Connecticut of doing resentencing of people who were sentenced to long or life without parole sentences as juveniles. So I would consult with people like Allie and lawyers that were doing resentencings and looking at second chances throughout the state of Connecticut, but I didn't have co-counsel in most of those cases. Although the first couple we did partner with the public defender's office in Connecticut with some great lawyers who again were welcoming of the students. But since then, in order to expand capacity and not just go to glom on to an office that already is doing the work, we have done most of the state cases without co-counsel. That and how we select cases. So in the federal cases, I depend on the federal defenders to identify clients they think are willing to and excited to work with students, and also cases that they think would most benefit from a real infusion of resources. Like we go from, for them, it would go from maybe 2 team members to like 4 to 6 team members suddenly with us. So that, cases where they really think they could use that. And then also in the state cases, we've done our cases in a variety of ways. Sometimes people write to us. Sometimes I learned about people who were founders of the unit that I mentioned, who are kind of considered leaders or elders and never asked me for help, but were kind and generous and explained to me what they were doing. And then I offered my assistance, our clinic's assistance. And then in one extraordinary case, the warden of the prison actually asked us to represent somebody. He said, here's someone you really should take a look at. And that's one of the things that I really found gratifying, both because it speaks to my client's truly, truly exceptional position and what he's earned, which is absolutely a second chance. And unfortunately, he has not gotten one yet. But also it spoke to their belief in our students. You know, they had seen students doing this work, and they were excited to see the students and impressed at their what they were able to accomplish. And so that felt really good. So we do have a client that we got through that really exceptional way. And you know, that's just to say that the stakeholders are paying attention, right? So they're paying attention to what we're doing, and they're paying attention to how we treat our clients and the energy we put in. And that's regardless of outcome, right? It's not about outcome. At one point, one of the counselors from the program called me, and he was an amazing human being. And I'm very sorry to say he died unexpectedly in a car crash last year. But he was an amazing human being. And he called me up one time, and he would call me from time to time and say, hey, I want you to talk to somebody. I think you could use your help. And at one point I joked around with him and I said, Counselor Moore, we've only gotten 2 people out. It takes us a really long time to do this work. I don't know why you're calling me. There are lawyers out here who move a lot quicker than we do. And that's something, you know, I should mention too, because the clinic it takes a long time because you're teaching students. You're not just kind of moving along. And so I always tell the clients, this is going to take a long time. And students go away for break and there's stuff. So you got to be patient or we're probably not the right fit. And Counselor Moore said to me, he said it doesn't matter because he saw that the students were so connected to the clients and paid so much mind and gave the clients and the students learned tremendously from our incarcerated clients and from our non-incarcerated clients. I can't speak enough to that impact. It is transformative for the students. So it's one of the main reasons I recommend this work. But anyway, that was really meaningful to me that he would say, you know what, it's not really about outcome. It's kind of like just the way y'all are operating along the way that really, I notice it, you know?
Yeah, I mean, it's funny because saying that it's not about outcome, I also see that though as an outcome. Like that's an impact on like the system, the world, your clients. You know what I mean? Like this is not, and also that recognition that ability to make those deep relationships and to be deeply invested in someone, you know, that has not had that in the system in which they, you know, that they've been living for so many years, how powerful that can be, not just for that one client, but as a model of, you know, how to treat people. Yeah. So I know that we're going to talk big picture about the why of this, but I think that is a really big why to say not just because I think there's an impact that you hope to have on maybe like standards of practice and things like that in these types of spaces. But there's also that piece where it's just like deeply kind of like recognizing and honoring someone's humanity in this way seems like that was noted and understood by the people in the system. And I think you actually helped us get a little bit to our next topic, which is about the impact on students, and thinking about, you know, why this clinic or you know, how this clinic makes sense for students' kind of educational development here. I think that one of the things that you brought up is also, you know, the challenge, which is that this is, you know, kind of deep and sometimes complex work that requires a lot of time and a lot of kind of runway to kind of get into it, right? So this is work that may, you know, it like challenges your students in different ways too. I think you also have to deal with like the frustration. Like in my class, we're supposed to go to the jail last week, and of course something went wrong, and you know all these. So like there are all the pieces that are great learning lessons, but also can be frustrations with students. But one area for me that I've seen that I think I'm excited about seeing my students understand is how much creativity is possible in this space, right? Where we have a goal and our client's goal is to get out. And what does that mean when you are 25 years out and sometimes there's not a mechanism that anyone has really seen that is like a standard piece of the procedure that you're going to use to get someone out. Or when we had a student that there was a very standard thing. There's a state habeas needed to be filed, right? But they were looking at the client, and they were looking at his circumstances, like he's really sick and he is like, it looks like he's nearing the end of his life. Like, what about a medical release? Like, what kind of, the ways that I'm seeing my students develop into like strategic thinkers and advocates is one of the things that has been most gratifying for me in seeing this type of work. How about for you, for the students?
Yeah, that's so important. I mean, when the clinic got started, I knew I wanted to do some sort of state post-conviction. I wanted to stay away from habeas if at all possible, because I didn't have any experience in Connecticut state habeas. And most of my experience was in federal habeas, and I didn't want to be constrained by all that labyrinth. I wanted to have a straighter shot at second chance. So I knew parole was an option for some set of clients, and there was also something in Connecticut called commutation, which is essentially like clemency, but that only applied to certain types of crimes. And the early students, I said, let's research like everything that seems possible on Connecticut's books. And they came up with a range of different there's motion to set aside an illegal sentence, and then something called sentencing modification, which seemed like it had criteria but hadn't really been used very much. And we thought, okay, well, I mean, why not? Let's give this a shot. And sentencing modification goes in front of a judge rather than a parole board. And it wasn't like available to every type of crime or every client, but it did, even people who had committed serious crimes could be eligible for it. So we did some cases under that. We've done parole. And I think that was really important, because I always tell the students, I'm learning right alongside with you. I really don't know much about this type of work. This isn't what I've spent. By the time I came into clinical teaching, I had been in practice for 19 years. That's unusual. And so I really was learning a whole new set of possibilities. And I know one of the awesome things about clinical teaching is you can, depending on where you're teaching and what you're allowed to do, but like you could reinvent your clinic 50 different times. I often say, if I decide to tomorrow, I could learn a whole new area of law alongside my students and do something different. And that's essentially what I was doing. So sentencing modification became a key part of our practice. And that was purely because the students researched it and figured out this was a promising avenue. A more specific example of this, which I love this story. We had a student who was getting a PhD in history at the same time as her law degree. And so she had a whole different lens on like record collection and resources than I did, or that anyone else on our team did, or that anyone really that I'd worked with before. So we had a client who had been told his whole life that he was born while his mother was incarcerated. But we had no evidence of that. There was no evidence anywhere of that. And we couldn't figure out, and his mother was deceased. And this historian decided at some point or another she was going to call like the state historical archives, a resource I never would have thought to consider. And she did a little PowerPoint for me at one point. She came and taught it to the students afterwards. And that's one of the things I love too, is when the advanced students teach the newer students and they mentor them. That is so gratifying. And she would come while she was still in law school and do this. And she got someone who said, yeah, we do have some records from that period of time at the women's prison in Connecticut. And let me just go through and see what I can find. And lo and behold, they produced this little index card that has a photo of his mother while she's incarcerated, like with her little DOC number, and penciled in handwriting says when she was transferred in and out of the prison, an abbreviation to the local women's hospital. And it was right when our client was born.
Oh, that's wonderful.
Yes.
Oh.
So we were able to include that in the packet. And I never, not in a million years, or anyone else on our team, but because of her interdisciplinary expertise, she did that. And so that's an example of where the students' creativity knows no bounds, honestly. And some of our students have lived experience with salient systems. And I can't say enough how much I learned from them and they learn from each other about how to do this work.
Yeah, I will emphasize that so much. Again, a year in, or less than a year in here, and just seeing what the students are bringing to this, like the kind of the lenses that they're bringing, because this is new to them, because it's fresh, but also because, like, so we had, former military students who had perspectives about some of like the weapons things in one of our cases, a social worker who was talking about like deaf culture and how that could have affected one of our clients, a martial artist who was talking about like some of the, cause of death questions that were here, and how things happen, right? Like, so just thinking about kind of and we have a little bit, we're going to talk a little bit later about how our students have affected us as practitioners, but that is one piece where I think I had expected to kind of learn how to teach this from the students, right? Like what worked and what didn't. But I don't know that I was like, oh, I think my practice has been elevated by these folks who are just, brand new and figuring it out. But I would absolutely say that that's the case in a short period of time.
Well, that's interesting because my colleague Kelly Barrett, who is my main collaborator at the Federal Defender's Office here in Connecticut, along with Carly Levinson, who's another lawyer there, they co-teach the clinic with me. And Kelly always says, I love to have the students because they have beginner's mind and they don't have any assumptions. And so they elevate us because they kind of clear the underbrush and we just come at it new, and that I really always think about that.
Absolutely. Absolutely. So let's talk a little bit about students and the challenge. So we've talked about all sorts of ways where students can enhance the work, but there's also the challenge, the other side, right? You talked about things take longer because we have to recognize that like students are going to take longer with cases. We have to teach while we're doing the cases. And so one of the things that I see as like a continued challenge is the length of time that it takes, especially when you have something in the open-ended and we're just trying to find a way to get somebody out. We might try several different methods and all that. So yeah, how have you figured out? So for me right now, I'm taking kind of discrete things. We're doing discrete things on cases that we can hand back. And then I hope that we'll be able to do these petitions, which generally will take, a year, and we can finish that. But who knows what happens after, right? Like who knows what happens after that's filed? Who knows what the life of that is still? So that's still uncertain. For you, you've had a lot of kind of iterations of this. How have you dealt with the fact that you might have several teams, like for one client, many students have kind of touched the case or going to meet the client for the first time, all of that? How do you balance that? And has that ever, been something that you've been like, oh, I'm not sure, that this works well for this particular type of client or not?
Yeah, that is hard. It's really hard for the clients, to have, especially clients who have had histories of abandonment by various people in their lives. And I really worry about that. And I always go in, or Kelly and Carly will go in and talk to the federal clients before I meet them or, talk to them. And I'll talk to the state clients that we're thinking about. And I always am pretty specific with them about what working with law students means. Like I said, there are going to be school breaks. They're going to they stay in touch usually over summer, with legal calls here or there, but it's not the same level they're used to. And then of course people graduate. And so some of my, like the client that I mentioned who still hasn't gotten a second chance, who the warden recommended to me, he's seen 4 or 5 teams at this point. And that's something that, we talked through, but you can't really prepare somebody for what that feels like because they really develop very intensive advocate client relationships, and it's really gratifying to see, but also really tough. So that is something I haven't found an answer to. It's just something that I feel is a feature of the work and in this context. And of course things happen too when you're not in law school, right? Lawyers leave firms or nonprofits and things, people make changes. But this is particularly cyclical. So we talk to the clients and try our best to prepare them for that and to say this will take a while because students are learning. I'm learning. Students are learning. And we take a really long time to do our investigation. So I will say to them, there are lawyers in the community who are getting people out of prison who are not taking as long as we do.
Yeah.
I'm really candid with them. I say that. I'm like, there are different models of practice. And
Yeah.
so I tell the clients that up front, and they get to decide. We haven't had anyone turn us down yet. And I think that's partially because the reputation is that the students will pay a lot of attention to your case.
Mhm.
And so we always say to the clients, you're going to have a lot more resources and time, because whereas some of us have multiple cases, the students will only have one. So that's one of the things, but that is a challenge of the work, and it does take a lot longer. We do hit pause. Sometimes I've had co-counsel who are frustrated because it's like, oh my God, we're on the academic calendar. And I'm like, yeah, that's kind of the deal when you're working with a clinic.
Yeah. Yeah.
So anyway, but of course, if there are emergencies and things like that, when the students are gone, we step in to handle it. That's why you're a clinical professor, you're a lawyer, you're a licensed attorney. So that's the flip side of it. But I think that's my sort of overview of that.
Yeah, and I mean, I think I thought about this a lot just as far as like student interaction. We actually had a client already that we had chosen that as a case. The work made sense, but actually it didn't make sense to have the students meet or talk to him because there were some significant, you know, um, issues that the client had. And that, clearly I think that's for me in the future, something that I'm going to have to think about, get a little bit more detail about like the client themselves, because I don't think that was the ideal. But I thought about that as far as just like especially when I've seen like good relationships being built, I'm like, oh, it's so short. It's so short. So I wonder about that, but I think still meaningful. You can have short and very meaningful relationships. So I think something to be realistic about though, as we're thinking about this
For
representation.
sure. Yeah, for sure.
And then do you have I think you already alluded to a story of like a memorable student client interaction or a favorite student client interaction?
Well, again, I mean, as I mentioned at the outset, this isn't necessarily just about the client. It involves other stakeholders. But one of the reasons that the federal defender colleagues were able to persuade me to start doing the federal reduction in sentencing cases is because it was during COVID and we weren't getting into prisons anyway. So I thought, well, if we're not getting into prisons anyway, let's try this out and let's see, how people do over the phone. And we had a client who was incarcerated at a federal prison in Texas, and the students had to really buck against norms there where they were not used to having regular legal calls, much less substantive long legal calls, not just like, hey, checking in to tell you I have a hearing coming up or whatever. Because people in the federal prison, Carly actually recently went to a federal prison and she said she was shocked at how few entries there were in the visitor log from lawyers. Some of them were from years ago, like on the same page, because people aren't used. So these counselors were not used to dealing with legal visits, calls, any of that. And they were resistant and hostile and they didn't like it. It was an intrusion on their time. And over time, one of my students in particular was really diplomatic and really persistent and just this is what we've got to do. And they managed, first of all, that client was just released from prison. He got relief a few years ago, but he finally was just released because of their work. And
Congrats.
yeah, really incredible. He's back with his mom in Florida, but he was in federal prison in Texas. And what I loved about that, she made moves with that counselor in terms of just again showing up for the client trusting the student team, the client wanting these calls, and he was a well-respected client too, so that helped. But the thing that moved me the most was when we had the virtual hearing, because again it was during COVID, that counselor came in on his day off to sit next to the client and be there because he saw how much this student client relationship meant, and it got him thinking and him invested. And this was a guy who was shutting us down in the beginning, and then he takes his day off to show up and be there. And that was incredible to me and showed just how amazing the students can be and how those relationships are transformative, not just for the lawyer or the more importantly the students and the client, but for the stakeholders and the people in the system.
Yeah. And I think that deep investment again, right? Like your clients are really pouring into or your students are really pouring into that client. And I think there's something that changes the dynamic so much about, people seeing that from like internally to your client to the other stakeholders as well.
Absolutely.
Yeah. So can you talk about, I talked a little bit about my practice and how just some of the, even just the specifics of how I break down cases and like the specific skills that my students brought has affected how I would see a new case. I also think being able to really I thought I had knew how to break down the fundamentals of how to approach these cases because I, worked with interns, I'd worked with new lawyers, all this, and still I did not. Like I feel like really getting specific about how do you get started when you just, have somebody else's file and an entire transcript and all that. Like I've learned a lot about that. How do you feel as far as kind of ways that your students have affected your the way you look at cases, the way you work on these cases?
Yeah, I mean, the students, like, I think definitely push pretty hard on really taking care with client, like, communication around really traumatic events. And so that's something that, I have learned a good deal about from my death penalty colleagues. And again, a lot of that's been from not lawyers, but mitigation specialists, psychologists, psychiatrists, social workers, so on. But the students now are much more, I think, attuned to just having an even more patient, I think, and capacious sense of how to approach difficult conversations. And they're very sensitive to the idea of not sharing trauma for sharing trauma's sake and really wanting to, so that's in tension with the idea that our job is to kind of investigate everything and figure out what's going to be most salient to a theory of mitigation that's most likely to get a client out. But I think I've learned from them about that. Of it's like we might learn a lot, but what do we actually really need to share, and what doesn't need to be shared in a public,
Mhm.
setting.
And
And yeah.
oh, go ahead.
Well, I was going to say the other piece of it is that we're really balancing our clients' rehabilitation story too.
Mhm.
So, like, whereas in death penalty practice, it might be like we just want to get this person's off, just get the death penalty off their back, and they can serve life without in prison, life in prison without parole. But for us, it's also we're showing our clients achievements and like the things that they've really shined and done inside or outside prison. So I think that's also a helpful balance to keep in mind. It's not just about like the really difficult things that happened before they were incarcerated. Sorry, what were you going to say?
No, I was just saying that trauma piece. And I know when I started in death penalty work, vicarious trauma and secondary and all that stuff was not a thing. Or I mean, it was clearly a thing, but not a thing that people were really talked about and trained about. And I think that's another thing, that piece that you said about recognizing clients' trauma and like recognizing how to take care of ourselves, I think is something that I think has been great in just clinical teaching. What's that?
It's a book that my blurry background isn't letting you see, but it's called Trauma Stewardship. And one of my closest friends gave me this book. I highly recommend it. The author's name is Laura Vandernoot Lipsky, and also Connie Burke, co-authors. And I had never heard of this book. She gave it to me like 2 years ago. But to your point, we do a really, really bad job, especially in the death penalty community, of contending with the layered trauma that this work puts on advocates. And my students are much, much better at recognizing it, and they've encountered this idea in other aspects of their life. So I've learned a lot from them about this. And also one of my colleagues, Jean Co-Peters, who's since retired. Yeah, she was around when you were in law school.
Yeah, yeah.
Really good at teaching about this. And I learned from her, and I said to her, you're giving your students a gift really early in their careers. And so a lot of my students come in with many, many more tools than I have, and I'm learning. So
I love that. And because of time, I think we actually have to switch to Q&A, but this is a
that's great.
good time for everybody to put their cameras on, and then we can do quick Q&A. And that's also a time to acknowledge my colleagues, because even the piece about like recognizing trauma and talking about trauma, like one of our my colleagues in the immigration clinic was like, oh, let's do a vicarious trauma, like co-teach, like combine our classes, and having colleagues who have social work backgrounds and things like that has been great for that, because just in this period where I'm like, oh wait, self-care, oh, we're doing that, okay, I guess I can give them an hour of self-care on their timesheet. I'm now convinced, but it took me a second. All right. And Miriam, I know you have a big idea about like your impact on the world. I was like, that was like my last question. If you have a chance to work it in, that'd be great. Otherwise, maybe you can have parting thoughts for us at the end after our questions. Um, but all right, any questions? Yes, Jennifer. Oh, you're muted.
Yeah,
Oh yeah.
I'm unmuting. So I'm this has been a really rich conversation, and it's hit a lot of buttons for me. Makes me wish that I weren't retired and we're back in doing it. But I ran a direct appeals clinic for many years and aspired to do a sentencing clinic with the idea of trying to raise the standard of practice in a local court where it was abysmal on this subject. And one of the reasons why I was so interested in that was I also tried teaching some state habeas stuff in addition to the appellate stuff, so as to get my students back into investigation. And that's my question, is really sort of how you are teaching about the fact investigation, because that seems to me to be an area that is massively and horrifyingly neglected in law school because it's hard, it's messy. But lawyers, you don't have a case without facts. Lawyers are information getters more than they are information givers. And their strategies for getting information are so important. So I'm interested in hearing about how you teach about that.
Thank you. Yeah. Oh, go ahead, Ngozi.
I'll do a quick one just because I had a great story from a student where I was like, okay, so this isn't about like the getting of the facts, but it was even just about creating a statement of facts. And we had just had all the things that had already been done. And I was like, okay, we're going to work on statement of facts. She's like, but what are the facts? Like, and I'm like, well, that's what we're doing. You know what I mean? She's like, oh, usually like maybe we have like one little piece that we have to take facts out of, but now we have to like choose which one fits our narrative, which one is true. So I definitely see that, where it's just like, and I know for me too, right, when even just going out into practice, where it's just like, oh wait, the facts used to be like your little issue spotter or something, as opposed to like the entire universe is your facts, right? So okay, Miriam, go ahead.
Well, no. So again, I'll just shout out, paralegals that I learned from in the death penalty context who taught me how to do these templates of work. So like I teach the students now, and then they teach each other how to literally, like, every conversation we have with a client or a witness or, mitigation witness, we write a memo, and it's thematically organized so that it's not like the client said this and the client said that. Then no, it's work product that's organized by theme. So if everything the client said about living, in whatever particular neighborhood during this meeting is there. And then they take that and they put it into what I've learned from my death penalty colleagues is called the theory memo. And that's organized thematically too. And it's like any theory they have about the client's experience that might be relevant. And so it's a way of like what Jean Co-Peters would have called mapping the client's experience. So we're taking what we're learning, but we're recording it so that, because who can remember? I can't remember what happened yesterday, much less something that a team discovered, 2 semesters ago. And if it's new team members, they need to be able to find it. And then there are timelines. So specifically like timelines, so you can see what was happening. Oh, when the client's grades tanked in 3rd grade, that was the same time his house burned down. So this is like very granular, but this is literally how we do it. And then there's a lot of work. The syllabus is very oriented towards trauma-informed record gathering, story gathering from our clients and the people in their lives, and records gathering, and then how to sort of piece it all together, how to work with experts who help us piece together the impact of trauma on our clients. And so that's an overview of how we do it. I hate to talk about things I've written, but I'm just going to put in the chat. I did write a law review article that kind of definitely like explains the model of the clinic. And so it gets pretty specific about how that work gets done.
I love that. And I think that's great to get into like the bigger picture too, how these little things, fit into the huge picture of what the impact is. I will also just say it's just like the little things too, like a cast of, like you were talking about timelines, cast of characters is one of the first things I have students do as they're doing a review of like who is where and what is, you know, their relationship and things like that. And that seems like a just straightforward thing, but that's something that you use and build upon throughout the case as well. So.
And even where their information, where the
Yes.
where the speaker's information is coming from. So yeah, I mean, and all the students have gotten up until now is like the police statement or that fact statement in the exam. Yeah, thank you very much.
And I'll also say that we do an early emphasis on storytelling, because for people to really break down the stories that have been told about their client, like the direct appeal, you know, I think that sometimes people are framed as like, this is it. And then you break it down to actually say, okay, so what are the components of the story that's told and how is that different from what might be the reality? And that's part of like us breaking that narrative down and then, you know, crafting another one throughout the case. Other questions? I guess one more question. Wow, time flies. My goodness. Yes, Deborah?
Thank you so much for this talk. It was incredibly helpful. I think I'm slightly differently situated because my clinic is an identity-based clinic in which we do a lot of criminal defense and post-conviction work. It's an LGBTQ advocacy clinic, and so we're only representing LGBTQ clients in these cases. So a lot of my students come into the clinic not expecting to be doing this work, and then, you know, are sort of thrown into it. And I think because of that, you know, in comparison with like a post-conviction or criminal defense clinic that's, you know, explicit about that work, a lot of my students really struggle with like the kinds of cases we're taking, and I typically involve my students in the decision-making process of which referrals we're going to accept, because we take cases from around the country, so we get a lot of referrals, and I really, there's a huge struggle around that issue of like who's deserving of our services and who's not based on their convictions or what they're being accused of doing. And so I'm curious if that comes up in your work, and if so, how you navigate that.
My clinic is straight up. It's called Challenging Mass Incarceration. And I actually shout out to Brett Dignam, who was my predecessor at Yale Law School, who called her clinic at Columbia Law School Challenging the Consequences of Mass Incarceration. So I cribbed from her. But it's pretty straightforward about that they will be doing this kind of work. I think like kind of what does happen is they come in thinking they're going to do sentencing post-conviction work, and then they find out they're actually learning a ton about like the island of Antigua because their client happens to be from Antigua, and like who knew they were going to become anthropologists. And you know, I had students who literally got on a plane and went to Antigua to try to get records. You know, I think they also wanted to be there in January, but you know, I think every case, I always tell students one of the coolest things I think about being a lawyer is that every case is its own like treasure chest and you have no idea what's in it. And so I think for all of the work, right, you're getting a file or something or some sense of what the client, you know, what the case is about, and then suddenly there's a whole set of issues that you had no idea was going to come your way, and that might not even be about the legal issues, but as someone put in the chat, relationships, or as Ngozi mentioned earlier, you know, navigating some problem with getting into the jail or the prison. That's learning, you know. And so I think for me it's just about keeping the students aware that we have to be nimble and open and exercise non-judgmental awareness of everything that's happening so that we can begin to exercise our judgment when it's appropriate to do that, to craft the case strategy and advise the client and counsel the client and come up together with what, you know, is going to ultimately be the advocacy piece. So yeah, I don't know if that's helpful, but it's definitely, that's how I think of your question.
And also we have scheduled how do you represent those people sessions, especially since we had a couple of cases that unexpectedly were innocents, and I'm like, we're not just like, let's just make sure not specifically all innocent. So but time has flown. It is the end. Thank you so much for spending this time with us. It was so great. Thank you, Miriam. And I just want to say thank you for all who are here today's conversation was recorded. It'll be made available on our website along with previous conversations. I think the link is in the chat. So thank you again.
Thank you, Ngozi. Take care all.